when you sent them that message, or are you lying now?
Neither.
Then which is it? Because you've told them you're covered by a warranty claim.
Right.
It can't be both, Mr. Baird. Stephen Fredakis versus Baird Services LLC and Premier ATX Industries. Do I have someone here on behalf of Beth Fredakis?
Yes.
Yes, ma'am, we're appearing.
All right. And the two of you are together, right, Mr.?
Yes.
Okay, got it. Good afternoon to you both.
Hi.
All right. And how about for Baird Services?
Yes, Brady Baird's here.
Okay. Mr. Baird, are you the owner of the LLC? Are you an agent, representative?
I was the manager, owner, yeah.
Owner, okay. And how about for Premier ATX Industries?
Good afternoon, Your Honor. Mike Truesdale. I'm on here on behalf of Premier ATX.
Okay, and you're counsel, correct?
That's correct.
All right. And we have no counterclaims or cross claims in this one?
No, Your Honor.
Okay, just make sure. I always like to kind of mark myself down here if I know there's some extra things that are happening. All right. Mr. Fredakis, I'll say that sort of for ease of me understanding and following along, and since we're all together like this, if you can decide amongst yourself maybe who is going to be the spokesperson, that doesn't mean you both can't testify, but in terms of what I guess sometimes people want to talk over each other, and that gets very confusing to the court. So if you'll kind of amongst yourselves work it out who you think would be the kind of the main narrator, that would be helpful. But then what we do is just quickly, you'll get a chance to make an opening statement. What I'm interested in really is tell me if you're suing the defendants for money or property. If you're suing for money, tell me how much money exactly it is you're seeking. If it's property, tell me what property it is that you want to have back. And then tell me kind of what's the theory of why the defendants owe you the money or the property. Is it a breach of contract? Is it a negligence case, like a tort? Is it a personal injury? Something like that, okay? That is not, you don't have to give me all of your information. It's just, it lets me know what am I going to be listening for in it. And then both defendants have a chance to respond. They can also wait until you've presented all of your evidence and testified, and then they can make a statement. They're allowed to kind of wait and see. That's just rules of court. And then after we hear from both the plaintiff, and if you meet kind of a threshold burden, we hear from the defendant, each side's allowed to ask each other questions. When everyone's completely done, we've heard all the testimony, we've seen all the evidence, then you get to kind of finalize it with a closing statement, which is a lot like the opening one that says, see, I'm entitled to the money or the property because of my evidence. All right. That's law school. I went 3 years, took out $100,000 in loans, and I'm giving it to you in 30 seconds. All right.
Thank you.
Worry not. You don't have to worry about addressing me by a specific name or thing. People get kind of tripped up in that. Just don't call me a bad word and we'll be all good. Okay. All right. Please tell me who's going to be our opening.
I will be the spokesperson.
Tell me what this lawsuit is about, sir.
So this is about money, and it's for the amount of $4,234.62, and it is for breach of contract.
Okay.
So the very, very short story is that at the time, my wife and I resided at 6 in Austin, and we contracted with Baird Services LLC for the building of a pool. The contract was entered on September 17th of 2021. The pool was concluded in April 2022. 2 months after that, we started seeing cracks, pictures of which we have submitted in evidence. And we contacted Mr. Baird several times from June to December asking for warranty-based repair. He came by, visited, and did admit that this was indeed warranty repair that was not done. Abruptly, in December of 2022, we were told that he went out of business. And as such, he could not fix the damage on a warranty basis. We contacted Premier Pools, which is a franchise. We contacted Premier Pools headquarters, and we started contacting other offices trying to find out who will actually honor now the warranty. On that basis, we actually filed a suit. And in May 2023, we awarded a judgment of $4,200. The judgment was stayed on the basis of the LLC veil was not able to be because we had sued him personally, and we had to resubmit it. And the suit was resubmitted, and the discussion was that we were not exactly the case. As a matter of fact, today we were not exactly sure who actually owns this warranty now. Mr. Baird has sent us communication saying that all his business is now provided for by the Georgetown-based pool services, ATX. We're told by Georgetown that they are a separate business. We never entered into a contract with them. So there is a contradiction. In the meantime, we actually had to pay a third party to fix the pool because the pool was cracked and such. Mr. Baird has provided us a letter, or I should say an amendment of the contract. I really don't know what it is. It appears to be a legal document, which we've entered into evidence that actually states that all his business and interest, including warranty, is now been assumed by Georgetown ATX that he has provided to us. So this is where we're at, and this is the case.
When we contacted Georgetown, they said that ours is not part of that. Some of them are part of that warranty, not all of them are part of that warranty, and they deemed that ours was not, and they gave us a quote to fix our pool. We did not go with them to fix our pool. So
tell me again why Premier is here. What's your claim against Premier ATX?
According to Mr. Baird, Premier ATX are the ones who have assumed responsibility for all his warranty work.
Are they Georgetown?
Yes, ma'am.
yes.
Okay, that's why I'm getting confused, because it's Premier ATX, but you're talking about Georgetown. That's where my loss was there. Okay.
Yes.
Sorry.
Okay. No, that makes so. Mr. Baird tells you that you have a claim, but your claim should be filed with Premier ATX. They've said that's not true. We don't own the warranty.
Correct.
Okay. All right. Thank you very much then. All right, Mr. Baird, would you like to make an opening statement or would you like to wait?
I can wait. Thank you.
All right. Mr. Truesdale, would you like to make an opening statement on behalf of your client?
Thank you, Your Honor. I would just say that we, on behalf of Premier, we do not have a contract, and we have no relationship that would require us to make the repairs, and so I will wait for other arguments to be made, but we're kind of strangers to this transaction. We did not build the pool. We did not inherit the pool, and we offered to contract to repair the pool, and our offer was not accepted, and so we were not retained to repair the pool. So, and so that's basically our position. Thank you, Your Honor.
Thank you. All right, Ms. Ferdakis, actually, and Mr. Baird, are you able to turn on your camera? Mr. Baird?
It's mute.
Yeah, I'm working on it here for you.
Okay. Oh, fantastic.
There you go.
If I could please have you and our plaintiffs, Mr. and Ms. Ferdakis, please raise your right hand for me. I'm going to go ahead and swear in all the parties. Do you understand that by appearing today and making testimony, you're swearing to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
I do.
Right.
I do.
And Mr. Truesdale, do you have anyone here on behalf of Premier, or are you going it alone?
No, Your Honor. I have a John Curl with Premier ATX online. So I think that he's on the call as well. So,
all right. And what is I see it as that for the person who's named Premier Pools?
Premier Pools one, I presume so. So yes.
What is his name?
John Curl, C-U-R-L.
All right, Mr. Curl, can you hear me? If you'll unmute.
Oh, there we go.
Yes, I hear you.
Good afternoon, sir. And do you have camera? Are you able to turn on your camera?
I'm trying, but it's not allowing me to.
All right. Well, will you please raise your right hand and swear to the court?
Yes.
Mr. Curl, do you understand that by appearing today and testifying in this matter, you're swearing to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Okay, fantastic. All parties have been sworn in then. We're going to start with plaintiff. So, Mr. Ferdakis, would you like to start first and present the information that you have for me?
Yes, ma'am.
Okay. So let me ask you a few questions because I'll kind of lead us along. You did a great job of the opening. I get exactly what we're here for. So, okay. You contracted with Baird Services to have a pool built. I think you said that was in September of 2021.
That's correct.
And was that did y'all have a written contract for that?
Yes, we have submitted it in evidence. We have a written contract with Premier Pools, which is a franchise under Baird Services for the territory that our home was at.
Okay. Let's see if I can locate that in the information here. So I see a 22-page brief. Perhaps it's included in that. Let's take a look.
What page?
And I'm going to share my screen. Mr. Ferdakis, if you tell me if you recognize this document. Contract between you and Baird. And
yes, ma'am.
That's not signed.
Defendant 1.
Where is it? We have a fully executed.
Miss Ferdakis, this is again why I said, who wants to be the person to answer the question?
Yes, this is the contract.
Okay. Right. I'd say write it down if you're not clear about this. But when I start having both of you talk, it gets very confusing to me, especially because we're all doing this in one big setting. Okay. All right. So this is the contract that y'all are suing under.
Yes.
Mr. Ferdakis, is that correct?
Yes, ma'am. Yes, it is.
Okay. Mr. Baird, do you recognize this document? Is this a copy of the contract between you and the plaintiffs?
Yes, it is.
All right. Mr. Truesdale, I recognize that have you ever seen this document before?
I'm seeing it now, but I do see that it says it's with Baird Services and not with
yeah, no, I got that.
Yeah, yes, Your Honor.
I get that.
Yeah.
What I'm hearing is that Mr. Baird's alleging an assignment of the duties under it. And we're going to look into the contract to see if there's anything about that. I got
correct.
it. So
yeah.
Just saying, okay, we can all say that this is the contract. So let me take a look at it. It's got Premier Pools and Spas. Now, is Premier, is that the company, like the big franchise name, and then you have people who buy that brand to use it? Is that what I'm hearing, Mr. Ferdakis?
Ma'am, if I may I bring your attention to the blue box in the first line, Baird Services doing business as?
Premier Pools. But my question is Premier Pools, did they franchise to be able to, Mr. Baird, he had to pay to be able to use that logo?
I assume so. I assume that he bought a franchise from Premier Pools.
All right. So I see yourself at the top here. The plaintiffs are labeled. I see the defendant here, Baird Services LLC. And then this is a pool, $78,000 for the pool. And then at the bottom here, there's signatures dated September 16th of 2021.
That's correct.
Okay. And this contract is the entire contract. Parties are not bound by any oral expression or representation like that, or by any agent of either party purporting to act for or on behalf of either party or commitment or arrangement to it. Now, is there more than one page to the contract?
Let me see.
Is this part of the contract too?
Yes, that's the second page.
And is this page part of the contract? All right, and this one too?
Yes.
How about this? This is Better Business Bureau. So
no, that's different.
Right. Okay. So we got 4 pages to the contract.
That's right.
All right. Is there any section of this contract that indicates what happens if Mr. Baird goes out of business or if Baird Services ceases to exist?
Not to my knowledge, no.
Is there any portion of this contract that details what happens if the product provided is faulty? Is there any warranty language in this contract?
Oh, yes, there are warranty provisions.
And what section is that?
That would be the warranty is effective only if builder has complied with terms and conditions and so on. So there's reference by reference.
All right. Let's look at 3 first. All right. So this
and
is
obviously
about what happens if they build it to the wrong size. Walks and decking are not warranted against cracking, chipping, raising, settling, discolorations. Plaster is not warranted against any of these things. Full equipment installation of accessories are installed, provided herein. They have their own warranty. Buyer must notify builder of defects or breach of the warranty in a reasonable time, no later than 10 days. Such notice will be sent to builder at its place of business. Warranties are effective only if buyers comply with all the terms and conditions. Becomes void if the pool is not kept full for a 10-day maintenance period. If it's damaged by water rising above the lowest point. Would it be rising above it or below it? You know what? I don't care.
But I don't think this is in dispute. Mr. Baird did accept that this is warranty work.
I'm just reading it, sir.
Fair enough.
Right. And I want to see if it says anything about what happens. Right. And is there anything in this contract that says what happens if the defendant ceases to exist? So there's a warranty here. I can see that. What happens if defendant wasn't around when you discovered something in the next year?
Not to the best of my knowledge, there is no such provision. But when the issue was brought up, he was still in business. He visited our home. He agreed that he was gonna, in his words, I'm gonna take care of it, which we've also, these communications we have entered in evidence.
All right. So you've got the contract. He builds the pool. You discover defects in the pool. You notify Mr. Baird about the defects you discovered. Does Mr. Baird acknowledge in writing that he's caused a defect or that the pool is defective?
He did say that I will take care of it. I will fix it. I have multiple texts from him. He came to visit the home and he said, I will take care of it. And that went all the way from when I reported it in June all the way to November. November 2nd, as a matter of fact, it was the day that he came to visit. When I followed up with him about doing it in December, he said to me that I'm out of business now and please talk to Premier in Georgetown who is taking care of all my work. I'm not quoting him verbatim, obviously, but that was the idea.
Okay, so you notified the defendant that the pool had a defect.
Yes, ma'am.
And did he, in writing, respond?
He sent me several texts stating that I'll come by, I'll take care of it, yes.
Okay. Do any of those text messages acknowledge that he is liable to make the repairs?
Yes, he said, I will take care of it.
What day are those messages on?
Here.
So those messages, they start from the original. Okay, the one I want to I think is the more explicit is Exhibit 4, where we said in November 15th, it's on the list. I don't have a day yet from him. That's when we were asking specific scheduling. And then on November 29th, I'm trying to get the mason there. He's backed up due to the wet weather. It will get done.
Sir, do you see my screen? Are these the text messages you're referring to?
Yes, these are the ones.
Are these screenshots from your phone?
They are.
Who is in the pink on the right-hand side? Who's that person? Okay, and who is responding on the left-hand side in black with the purple dot?
Mr. Brady.
Okay, and so here I can see it looks like November 10th. Hey, Brady, following up on the visit to arrange the issue we discussed, let me know when we can get this done. Any news on scheduling? Can you please update me? Those are subsequent. And then November 15th, it's on the list. I don't have a date yet. So he seems to imply that, yes, he's going to make repairs. He just doesn't have a date for you. And then 14 days pass and you say, hey, it's been 2 weeks. Do we have a date? He says, I'm trying to get the mason there. He's backed up due to the wet weather. It will get done. So, all right. Mr. Baird, do you recognize these text messages?
Yes.
All right. So this is you agreeing that the work is going to be repaired?
Correct.
All right. And then all of December passes, and Mr. Ferdakis, in January, you said, hey, I still haven't heard back from you. At any point, was the repair work completed by the defendant?
No, there was no. The response, as a matter of fact, to the January 3rd is that I'm not in business anymore. Please contact Georgetown, who will be now taking care of my business.
Okay. And is that a text message or an email? Where is that?
No, this was a voice conversation, actually.
Okay, so he called you and said, I'm not in business anymore.
Correct. But I do have a communication. I do have a text eventually. It was not a direct response to this that states that I'm not. So just a moment, please. So look at Exhibit 5, if you may, where we say, we've closed our company. Please reach out to Premier Office in Georgetown.
Mr. Ferdakis, this is the exhibit you're referring to?
Yes, ma'am.
Okay, now again, on this one, is this a screenshot from your phone?
That's the same exactly as I mentioned before. It's the pink would be me, and the black would be Mr. Brady. And obviously my response to that is I'll be looking for legal advice once he announced me that his business is out. And then I said, why would I contact, you see, again, the black, why would I contact Premier office in Georgetown? As I'm seeking, his response would be to my saying, seeking legal advice. He said, why contact Premier and submit a warranty request? That would be Premier in Georgetown.
Mr. Baird, do you recognize this text message?
Yes.
And is that what you instructed them to do, to contact Premier in Georgetown?
Yes.
All right. And Mr. Ferdakis, did you indeed follow up and contact Premier?
Yes, ma'am. And they were very, very helpful, but they said, we do not do that. They were actually offered me to provide me a quote to do this work at my cost. I received the quote, but obviously the quote was a bit expensive, and I decided to go with somebody else. But at no point they accepted to do this work under warranty.
Okay. All right. Mr. Baird, do you have any questions for Mr. Ferdakis?
No, I don't.
All right. Mr. Truesdale, do you have any questions for the plaintiff?
No, Your Honor. Thank you.
All right. And Mr. Baird, I'd like to hear from you next. So
Okay.
it doesn't seem to be in dispute that the pool needed to have repairs done. Why do you believe, or what information do you have to show us that the warranty is going to be honored by Premier in Georgetown?
There was a document, I don't have it with me. I think it's in that pack of documents you have, that was signed between me and John and our corporate office, I believe. I don't remember the details. If John said that their pool didn't fall in the scope, I don't know the details on that. I know there was a general warranty that was being passed along when they took over my territory.
Have paperwork to support that?
I do somewhere. I do. My attorney had it.
Respect, Mr. Baird, today is the day to prove that you aren't responsible
personally
for this.
No, I don't have it. No, I don't.
All right. Did you have insurance?
I did.
Are you required to be licensed by the state of Texas to install pools?
No, ma'am.
Were you a single member LLC?
Yes.
Mr. Truesdale, do you have any questions for Mr. Baird?
No.
All right. Just so I'm clear on this one, absolutely no one has anything in writing to affect that Premier ATX in Georgetown has a responsibility to take care of the pool warranty.
We submitted it.
Ma'am, we submitted, I think, the paper that Mr. Baird is referring to, and it is, it appears to be part of a contract that he gave that to us, as a matter of fact.
Is it part of the original, those 4 pages that I was looking at?
No, it was a supplementary submission.
September 14th.
September
If
14th.
that's the case, I have not seen any of the.
We'll get there.
No,
You
that's
were
fine.
copied.
I just
No,
want to.
let's take a look. I get it.
Mr.
Okay.
Truesdale, you were copied.
In the 22 pages you originally submitted, is it part of that brief or is it a different document?
No, it was a different supplemental submission. It was on
Okay,
September.
all right, let me look through and see if we can find it.
Okay.
And it was emailed to him.
Okay, it says business modification terms, March 1st, 2022. Parties, Baird Services LLC, Premier ATX Industries. And it is signed between Amy and Brady Baird and Christy and John Curl.
I have this marked as defendant's exhibit. Maybe it's mislabeled. Let's see. Business modification terms.
Yes, that's it.
Okay. All right, let's take a look. All right, now, Mr. Ferdakis, who drafted this document?
This is not my document. This is something that Mr. Baird has provided to me.
Mr. Ferdakis, that's what I'm asking. Who wrote this? Did you write it, or did Mr. Baird write it? Did Mr. Truesdale write it? Did it come from the sky? Like, did you write the document?
No, this is a document that Mr. Baird provided to me by email. I do not know about the author of this document.
All right, and then at the bottom of this here, I see Amy Baird, Brady Baird, Christy Curl, and John Curl.
And as I said before, I believe this is the document that Mr. Baird was referring to before.
But this is not a document between you and the defendant.
No,
This is something the defendant sent you.
that's right.
Okay. And this is dated at the top March 1st, 2022. Mr. Baird, do you recognize this document?
Yes, ma'am.
Did you provide this to the plaintiffs?
I may have. I thought my attorney did, but I possibly have forwarded it on as well.
All right. What is this a document? Well, let me just take a look at it. Let me see what it purports to say. Okay.
There's another piece of it.
ATX will remain premier pool and spas. Austin will expand their territory south, including BS existing territory. That's Baird Services, if I'm going up here and looking. And then Premier ATX Industries, LLC. All right. So the defendant's going to change names. They're going to become Pinnacle Pool and Spas. They're going to expand their territory. Under that name, they're going to sell fiberglass pools. ATX is going to sell gunite pools. Each company agrees to refer each other any pool service they don't use. So I'll do one, you do the other. We'll refer back and forth. In other words, yep, that's exactly what it says. Look at that. Any gunite project that has been sold BBS prior to March 1st and not yet dug shall become property of ATX and will be built under their premier brand. So if they had a contract but they hadn't done it, ATX was going to own it. ATX will pay them in accordance with the commission schedule, half at dig and half at close. This provides them time to close any existing gunite leads they're working. ATX is going to give a 2.5% fee for gunite projects. ATX will pay the defendant $60,000 advance on those fees. That's drawn, deducted from it. And they give an example, separate spreadsheet for track and dig. ATX will assume most of the warranty work for gunite pools built by the defendant in the territory for the customary 12-month period. The exception to this, any shotcrete warranty or any warranty that is determined to need to go to be turned over to insurance. Or any warranty that is determined to need to go to be turned over to insurance. Okay. Examples of warranties to be covered are minor tile repairs, plumbing, leaks, equipment. Effective immediately. We use them as a trade partner and its contents on property on March 1st. So this is the section that's really relevant to what we're talking about today. ATX will assume most of the warranty work for gunite pools that the defendant built in the territory for a 12-month period. The exception would be any shotcrete warranty or warranty that is determined to need to go to be turned over to insurance. Mr. Ferdakis?
Yes, ma'am.
Did you have a fiberglass pool or a gunite pool?
Gunite pool.
Mr. Baird, is that correct? Did the plaintiff get a gunite pool?
Shotcrete is the material used for the shell. But yes, gunite, shotcrete are basically the same thing.
Okay. Mr. Truesdale?
Yes,
I believe that your client is Mr. Curl, correct?
that's correct.
Mr. Curl, would you like to ask him if he recognizes that this is his signature on this contract?
Yes, it is.
Okay. And so it says to assume warranty for a 12-month period, right? And this was signed February 2022. And their pool was built September 2021. So, Mr. Truesdale, with that information, does that change your client's response?
No, not at all. The warranty, no, it does not.
Well, this is clearly a contract between your client and the defendant, co-defendant, that covers warranties. And it seems to cover the type of pool that the plaintiffs are alleging had a defect. And I haven't had any information introduced that the defendant 1, filed an insurance claim. And in fact, what they've shown me is that in text messages, he said, yep, we're going to send someone out to fix it in the Mason part, which seems to be under this.
Judge, if I may, with regard to insurance.
Mr. Ferdakis,
go ahead.
Not necessary.
Okay,
I'm right. It is never in anyone's interest to blurt out things. Mr. Truesdale, I'm asking a legitimate question here, right? So in October, they notified the defendant, Mr. Baird, about the problem. Mr. Baird, in November, agreed to get a mason and fix it. So there's no indication this is something beyond what is the scope of this. And then when it didn't get done, he said, hey, I'm selling. And that's probably because he was working on the contract. And that contract with your client was completed in February, which is in the 12-month period that this would be covered.
But the bottom line is that we never had any contract with respect to this particular pool.
I think it's covered right here.
Well,
ATX will assume warranty for gunite periods built by the defendant one in this case, in the territory for 12 months. And your client signed it. And they agreed then to refer cases, to refer ongoing business forward on each other. So if that's not an assumption of the risk, I don't know what is.
Well, it's not assumption of the risk; it's assumption of any kind of contractual obligation. But I don't think that we assumed any obligations associated with Baird with respect to this obligation. We did not do that. I mean, that was not the point of the contract.
What would be covered by this then, Mr. Truesdale? Because this absolutely says will assume warranty work for gunite pools built by the defendant in that 12-month period. And that falls within this. Otherwise, it wouldn't be here.
Would it help if I enlightened a little bit on this?
Yeah, Mr. Curl, because this seems to include that you guys are taking over warranties that he'd been given out.
Well, there was no purchase of Baird services. This is just a territorial thing within the Premier Franchise Management. But what it refers to, is my understanding at the time of signing, is that anything that was a structural defect, any cracks, anything of that nature, has to go through Baird services or their insurance or whatnot. The general warranty as it specifies there, like pool equipment, plumbing, things of that nature that are kind of standard warranty items. But anything structural pertaining to shotcrete, and if they have any cracks whatsoever, that's what that's referring to, has to go back to them. And that's really all that it was. It was a way to allow Mr. Baird to get out of it's an internal document. I don't really know all the details of what was going on, but on his end, but we didn't take on any major liabilities whatsoever, or anything really, on this internal document.
What would you have been taking responsibility for if you said we will assume warranty? I mean,
so all the manufacturer warranties that apply to, a swimming pool. So, for example, pool equipment, things of that nature that have a manufacturer warranty.
I don't agree with that, Mr. Curl, because when I go back and I look at the contract that the defendant was giving out, it exclusively denies that. If it's a manufacturing situation with a pool equipment, the plaintiffs were required to go and file a warranty with the manufacturer. This is about the part that Mr. Baird performed, the building of it. And so it seems to wholly include that. Because when I look back at terms and conditions, number one, pool equipment and accessories installed carry a warranty by the manufacturer. So you didn't need to get that disclaimed. It's already taken care of in the original contract that Baird was giving out to his clients. The contract between y'all says you take over things, which I can understand why. Mr. Baird, do you want to enlighten us? What did you think it meant? Because clearly you thought this covered your warranty, and that's why you referred the plaintiffs there.
Yeah, so the part in that internal contract with me and John Curl, the point that where we're missing all this is the structural items, the insurance claims. That pool is, and Truesdale knows about all the ASR going on in Austin. ASR is cracking every pool in town. There's thousands of pools broken here. The warranty that John agreed to do was not ASR related structural damages.
Why did you refer the plaintiffs to them to file a warranty coverage if you're now saying it doesn't count?
Yeah, because at that time,
did you lie to the plaintiffs when you sent them that message? Or are you lying now?
No. Neither.
Then which is it? Because you told them you're covered, file a warranty claim. Right. It can't be both, Mr. Baird.
I agree.
When I close
you ready? I'll go. When we closed our business because we had multiple pools cracking. We didn't know what was going on. We hired engineers. Come to find out, it's ASR, alkali silica reaction. Thousands of pools in Austin are breaking. We got out of the gunite game. I sold it from the time I turned it over to John, within 6 months, I had my engineering reports on all the pools I had built that I needed to go to insurance with. We verified that it's ASR. And since then, we've probably turned in 200 pools for insurance. The people that shot their pool that provided the shotcrete is one of the biggest players in the shotcrete game, and they have thousands of cases against them right now. The ASR cracks pools. It cracks gunite shotcrete structures, which travels up through the tile, cracks the tile, cracks the plumbing, cracks everything. The day I stood in their backyard, had no idea. I was just wanting to do fiberglass. Within 6 months of me having over 200 customers call and tell me their pools were breaking, we hired the engineers. We know what it is. So now everybody's getting turned into insurance.
Have
The
you filed an
Ferdacuses
insurance
know
claim
this.
for the plaintiffs?
They called the insurance themselves and found out that it was denied because of some.
That's not what I asked you, Mr. Baird.
What'd
Did
you ask?
you file an insurance claim per what you just said? Did you, on behalf of the Ferdacuses, whose work you did, and you said it's not my fault that it messed up, there's some other reason for it, have you pursued an insurance claim on their behalf since they're your clients and they gave you money and you told them you would take care of things? Have you done that for them?
No, ma'am.
And until today, had you ever indicated to them that it wasn't up to ATX to cover the warranty?
No.
Okay, Mr. Truesdale, do you have any questions for Mr. Baird? Mr. Ferdakis, how much money did it cost you to repair the pool?
$4,234, and I'm sorry, let me put up the cents. Doesn't really matter. 62 cents. 42.34.62.
And that's the amount that you're seeking?
Yes, ma'am.
And how much did you pay for the pool again?
78,250.
All right. Mr. Truesdale, do you have any questions for the Ferdacuses?
No, Your Honor.
Any questions for your client?
No, Your Honor. No.
Any questions of Mr. Baird?
No, Your Honor.
All right. Mr. Baird, do you have any questions for the plaintiffs?
No, ma'am.
Any questions for Mr. Curl?
No, ma'am.
All right. Just so I'm clear, $4,200 is 0.05% of the total price paid by the plaintiffs. Right. I do find that they've met their burden of proof today to show that they had a situation for which they gave notice to the defendant of it. Defendant did provide Defendant Baird. Defendant Baird provided them with information in writing, both in text messages and then later a supplemental document to indicate that they had a warranty that they could pursue with counter defendant or with second defendant here, Premier ATX. When I read that document, there is some not great language in it, but that is not to the detriment of the plaintiffs here. In fact, what I read seems to include that. So I am going to find in favor of the plaintiffs against both defendants in the total amount of $4,234 plus their cost of court. Again, this is a small claims justice court, which means we're not a court of record. Both parties are welcome to appeal that decision. Again, all three parties are encouraged to try to settle or otherwise reach a resolution. Okay? Good luck to everyone. With that, all parties are excused.
Thank you, Judge.
Thank you.
Thank you all. All right.